and go to the next step that you say that you may not have a respondent.
That's right.
Okay. Will you be satisfied in that regard?
No, I'm satisfied in terms of section 172. That is it's a preemptory provision.
Which says?
Which says that the court, in exercising its inherent powers,
Yes.
must determine, must hear and determine, and then issue a declaratory order in terms of that section on the validity, on the consistency of this, because we are setting a precedent where a president can escape scrutiny and choose another deponent because there are perjury implications.
Yeah.
Yeah. So
Another deponent? Proceed.
that's right. I'm not challenging his deposition. I'm challenging the conduct of the president in authorizing the litigation, the opposition to my application. That opposition was a decision made not by deponent. It's like a company. The company itself must be authorized before I can appoint attorneys. I can't challenge attorneys when they have no one to appoint them. So section 172, subsection 1, subsection A is a constitutional provision, and it requires a constitutional decision by the court. But the discretion is limited to a declaratory order.
All right. Are you done, Mr. Mawere?
Yeah.
All right, Mr. Mawere. That declaration, whether the president can instruct someone, in this particular case, Advocate Mutumwa, is based on the fact that you brought an application against the president and then he made the decision to get Advocate Mutumwa. Am I correct? Or am I not?
My lady, it's not correct.
Please educate the
Yeah, I'm saying he deposed an affidavit and averred that he is authorized. That authority is founded on law.
right? Authorized to do what?
Authorized to prosecute, not to act as a representative. I have no problem with an attorney acting under instructions. They are creatures of instructions.
Yes.
I have no issue with that.
Yes.
My issue is the one who authorized. Does he have the authority?
Does the president have the
Yeah, that's what my question is.
authority to do what
Authority to oppose an application.
against the president?
No, against the motion.
I don't understand.
I am the
Because-
applicant.
Yes. If
I want to know whether the decision to oppose my
application.
application
That's correct.
is lawful and valid.
All right, hold on. When Advocate Mutumwa answered, she answered with regard to her representation. And you say, does the president have the right, or did he act lawfully to instruct Advocate Mutumwa to represent you against your application?
No, I'm not asking that.
No, then I don't.
Yeah, I'm saying if you read the papers, my lady, the one who is processing, I don't have a paper from the president. This is not the first time we are crossing this bridge. Before the president himself had to issue, after challenging authority, he had to issue a confirmatory affidavit which confirmed that there's no authority. In the case number 2022 045016, you see a confirmatory affidavit from the president when we said we can't keep on going on in circles. So the question is not to act on behalf of somebody. That's agency. I'm not challenging the agency of the state attorney. I'm challenging the conduct of the one who authorized him, whether that exercise of public power is consistent with Section 2 of the Constitution. And that the court must make a declaration after hearing. But a satisfaction is for Rule 7. That's when you need the court to satisfy itself. But we're dealing with an oath-taking person, the president, whose duties are prescribed in terms of the Constitution as a supreme law. What I'm hearing the advocate is saying that no, the president is above the law. He relies on some opaque rules, legislation that is subordinate to the Constitution. This application is about the supremacy of the Constitution that compels the court to determine and declare, not to determine and be satisfied and then we proceed.
You refer to section 2 of the Constitution, right?
Yes, my lady. Okay.
This Constitution is the supreme law of the Republic.
Yeah.
Law or conduct inconsistent with it is invalid,
That's all.
and the obligations imposed by it must be fulfilled. Full stop.
By everyone, including a judge, including Then read it in terms of section 172 now. Then you see the link. And that places the court in this position where we can't just roughshod it.
Which conduct is inconsistent with the Constitution?
The authorization of the prosecution, the decision and acting on it to oppose my application. So if you
Hold on.
yeah.
Hold on. Advocate Mutumwa, do you have anything to say with regard to the fact that the president acted inconsistent with the Constitution in authorizing legal representation to oppose his application? Because he says that administrative act was invalid.
Yes, my lady. My lady, we have a subsequent to Rule 7, bracket 1 by Mr. Mawere. What we have done, we receive a Rule 7.1, and then we also receive an application following that rule. The application is the one which was issued on the 31st or the 30th of April. That is where this, the argument that is raising before the court are raised, the outsourcing of the presidential authority and everything. But what we have done, we filed a supplementary heads of argument to address those issues.
Before we get to heads of argument,
Yes,
did you file your authorization?
No, my lady, we have not filed authorization because the instruction to the state attorney, Mr. Mawere is only objecting to that the state attorney has not been authorized to deal with this particular matter. And that is what he's saying in his papers. He's saying to deal with this, especially the counter application. The state attorney has not been authorized to specifically deal with this particular matter. And then
With the counter application?
with the counter application, I think that is.
But he is also saying to oppose his application. Let us just make sure, because we've been going in circles.
Yes,
She's misrepresenting me, my lady.
Am I correct, Mr. Mawere, by saying that you are saying they don't have the authority to oppose your application?
To do anything.
Is it?
To do anything, including opposing, counter, or anything.
Thank you, sir.
Yes, yes, my lady. My lady, if I may answer in this manner, the state attorney has been given an authority. What we have not done is that in this particular case, because of the statute and because of the complaint that was raised initially, the complaint was filed in terms of Rule 7.1. Rule 7.1 is not applicable to the state attorney. And then Rule 7.5 is specifically saying that there will be no challenge to the authority of the state attorney. And Rule 7.1 deals with any attorneys. And then this is how we have answered. The reference is made to the State Attorneys Act in terms of Rule 7.5. Because the state attorney is an institution that is established in terms of the act, and then that's where the relationship between the departments, the organs of state, and the state attorney comes from. So we're saying the argument, especially in this case, because the issues which are raised in the papers brought on behalf of the president or in the counter application as well as the opposition, those are legal issues, and the attorney, the reason why he has to depose to the papers is because those are legal issues that can be raised by the attorney, but we have also made available of some cases for this honorable court which covers these issues of authority. We made them available and we have downloaded them on Christmas. So we're saying the issue. My lady?
Referring to the case that you have downloaded.
There's a copy, my lady.
Mr. Mawere, Chair, access to case files.
Yeah, I have access to this line. Yeah, but also I'm just a bit concerned, my lady, at the continued misrepresentation. My issue is not about delegation. My issue is not about authority. My issue is about the foundational principle of this constitution. Nobody is above the law. The president has no title or jurisdiction to make any decision that is at variance with the constitutional prescript. Validity and legality of conduct is subject to Section 2 for everybody. And what I'm hearing here is that exception, the case law or whatever, there's no precedent. It's clear. Invalidity is ab initio from the beginning, from the mind of the president. So this business of going through
What is the invalid act of the president?
authorization, just even the decision to oppose an application that is in the interest of justice. In terms of Section 173, even the court's inherent powers are subjected to the interest of justice as the only variable, not the person's position, as I'm hearing from the advocate, that the president has the authority that exceeds what is prohibited in terms of Section 2. Invalidity has to be determined by a court, High Court, Supreme Court, and the Constitutional Court, but this court has inherent jurisdiction to deal with that dispute. That's why I'm bringing it here. I'm not bringing a Rule 7. I only brought a Rule 7 just to test whether the sincerity of this process. That if I challenge authority as one variable, would the president appreciate that he's not above the law? This is not the first time he issued another invalid confirmatory. How can you confirm invalidity, illegality? And it stands. Then I speak to the attorney, state attorney, to say, guys, protect the republic. He's treating me like a scavenger, like a vexatious. This matter should not be before this court, my lady.
Then why did you bring it before us?
2021, the president has been aware of this, but he's stubborn.
No, sir. You said the matter should not be before this court.
Because it was already before another court, it was treated like parapara. I'm not para.
Let us please restrain ourselves to your application and your argument. I do not have any other matters before this court. Let us not bring the media and other things before the court, right?
Okay.
The issue is the president's decision to decide to oppose this application.
That's right.
Period.
It's an exercise of public power. I'm not dealing with a non-state actor. The Constitution is the law.
Well done, sir. You say that exercise of public power is contrary to the Constitution.
That's all.
Why?
It's contrary because in itself, anything, the president is bound by constitutional prescripts. He must obey.
You do understand that you didn't give me a content answer.
Which one?
You did not answer the question.
Yeah, the president is bound by the constitution. Okay.
Give me the answers also.
My lady, maybe.
You already stated that it's bound by the Constitution.
Yeah, I'm saying that.
I'm asking the question. You say that the president acted contrary to the Constitution, like exercising his public power and by exercising the power to appoint opposition to the, not to the appointment, but to oppose the matter.
That's right. Yeah.
Now, indicate to me where in the Constitution, as you say, violated the Constitution by doing so.
That's right.
Does it say that the president may not oppose?
Let's take section 2.
I read it for you.
Yeah. Let's take section 83, subsection B.
83B.
B83B. Yeah.
President.
Yeah.
The head of state.
Yeah.
That is A.
Yeah. The B one.
The head of state and head of national executive.
That's right.
B. He must uphold, defend, and respect the Constitution as a supreme law of this republic.
That's right.
How did he violate it?
Okay, the first thing is that,
How did he violate it?
yeah, let me check. The foundation of the assertion of rights and claims against a South African citizen were founded on a law that violates the doctrine of separation of powers. Secondly, that violates the doctrine of due process of the law. That violates the doctrine of equality, the doctrine of audit. So underpinning this is a foreign creature of statute, which is not a company, appearing in South Africa to assert rights and claims. So anything that is contaminated by unlawfulness and illegality, the president has no jurisdiction. The court has no jurisdiction. Even me, I have no jurisdiction. So this is the foundation of this. When he says he is representing my company, without even seeing anything wrong, and I'm sitting here, the company was stolen by thuggish abuse of public power in Zimbabwe. So I'm saying the president is aware that at the core of this is a Zimbabwean law that was created for the purpose of expropriating property against section 25 subsection 1 of the Constitution of South Africa. So in that, the knowledge of that,
expropriating property in Zimbabwe.
South Africa as well, the claims against me, the sequestration is founded on that law, repugnant, draconian. So that is